Selamat pagi, Bapak, Ibu, rekan-rekan sekalian. Selamat datang dalam kuliah umum yang bertajuk Good Neighbor Provision, Menilik Ketentuan Pencemaran Udara Lintas Batas di Amerika Serikat. Selamat pagi, perkenalkan saya Bella Natania, peneliti pada Indonesian Center for Environmental Law, ICEL. ICEL adalah lembaga non-profit yang bergerak pada isu hukum lingkungan hidup yang selama 27 tahun telah menjadi poros pertempuran untuk memenangkan pengembangan hukum lingkungan di Indonesia. Pada kuliah umum hari ini, saya telah ditemani oleh Profesor Richard Traves, Tapi sebelum berdiskusi dengan pembicara, mari kita dengarkan terlebih dulu pengantar diskusi dari Mbak Grita Anidarini selaku Deputi Direktur ISEL. Kepada Mbak Ninda, saya persilahkan.
Terima kasih banyak, Mbak. Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi, salam sejahtera, namo buddhaya, salam kebajikan, Om Swastiastu. Saya mewakili ISEL mengucapkan banyak terima kasih kepada Bapak-Bapak, Ibu-Ibu, dan teman-teman sekalian yang word time there because it's already late night, but thank you for your time. Bapak-bapak, ibu-ibu, dan teman-teman semua, mungkin sedikit latar belakang terkait dengan diskusi hari ini. Mengapa pada akhirnya ISEL mencoba untuk mengangkat isu ini? Karena memang isu terkait pencemaran udara lintas batas ini tentunya bukan hal yang saja menarik untuk kita bicarakan, namun juga penting dan relevan untuk kita bicarakan sekarang. Kita semua mengetahui bagaimana terkait dengan pencemaran udara itu tentunya tidak terbatas dan tidak bergantung pada wilayah administrasi saja. Saya ambil contoh misalnya bagaimana penelitian dari Center for Research on Energy and Clean Air. Mereka menyatakan bahwa bagaimana pencemaran udara di Jakarta itu tidak hanya diakibatkan oleh sumber-sumber pencemar yang ada di Jakarta saja, tapi juga sumber-sumber tidak bergerak yang ada di wilayah lain, seperti Provinsi Banten maupun Provinsi Jawa Barat, itu ternyata juga turut berkontribusi terhadap menurunnya kualitas udara di Jakarta. Nah, memang masih banyak sekali tantangan terkait dengan hal ini. Salah satunya memang terkait dengan bagaimana belum ada satupun regulasi di Indonesia yang mengatur terkait dengan hal ini, yang secara spesifik mengatur terkait dengan pencemaran udara lintas batas. Dan di sisi lain juga gugatan-gugatan yang masuk atau kasus-kasus yang ada juga masih cukup minim, di mana hingga saat ini masih terdapat satu gugatan yang masuk yang diajukan oleh masyarakat sipil dengan menggunakan konsep pencemaran udara lintas batas tadi. Nah, berangkat dari hal ini memang pada akhirnya ISEL melihat sepertinya penting untuk kita untuk mencoba menilik mungkin bagaimana ketentuan di negara lain, mencoba untuk belajar dari negara lain yang telah mengatur terkait dengan hal ini. Oleh karena itu mungkin hari ini kita akan secara fokus berdiskusi terkait dengan bagaimana ketentuan hal ini di Amerika Serikat, dan hal ini juga tercantum atau ada dalam buku Prof. Rivas sendiri. Judulnya adalah Struggling for Air, Power Plants and the War on Coal, di mana Prof. Rivas saat itu dalam satu babnya yang berjudul Bad Neighbor itu menuliskan bahwa banyak negara bagian di US itu yang memang gagal untuk memenuhi baku mutu udara ambien mereka. Di satu sisi memang baku mutu udara ambien tersebut semakin ketat dari waktu ke waktu, tapi di sisi lain ada sumber-sumber emisi yang ada di satu negara bagian atau di satu states yang itu bisa berpindah ke states lain dan membuat states yang bersangkutan itu kemudian tidak bisa comply dengan baku mutu udara ambien mereka begitu. Nah, untuk itu beliau juga menyatakan bagaimana pentingnya untuk adanya pengaturan terkait dengan pencemaran udara lintas batas ini yang akan menjadi diskusi kita pada hari ini. Nah, di US sendiri, mungkin saya nanti mungkin Profesor Rivas juga akan banyak berbicara terkait dengan hal ini. Bagaimana ada pengaturan terkait dengan good neighborhood condition atau pencemaran udara lintas batas yang sejak tahun 2011 kalau saya tidak salah itu sudah masuk ke dalam US Clean Air Act, di mana ketentuan ini menetapkan bahwa setiap negara bagian atau states itu perlu untuk membuat states implementation plan untuk mempertimbangkan adanya pencemaran udara lintas batas dan memastikan untuk masing-masing states untuk bisa comply terhadap baku mutu udara ambien mereka. Dan tidak hanya itu, nanti mungkin Profesor Rivas juga bisa bercerita bagaimana di state implementation plan tadi itu juga melarang adanya sumber-sumber pencemaran udara yang akan berkontribusi secara signifikan pada kemampuan states lain gitu untuk bisa menaati baku mutu udara ambien nasional mereka. Nah, kalau saya coba kontekskan dengan Indonesia, memang kita sekarang punya ada PP 22 tahun 2021, di mana di situ juga sudah ada amanat untuk rencana pengendalian pencemaran udara mungkin. Namun memang secara konteks mungkin agak sedikit berbeda, karena kalau di Indonesia ketika wilayah perlindungan mutu udaranya itu sudah lintas provinsi misalnya, kemudian rencananya itu dilakukan oleh nasional, kira-kira seperti itu. Beda dengan ada yang di US, di mana masing-masing states perlu untuk membuat perencanaannya dengan berkoordinasi dengan states lain terkait dengan bagaimana mereka bisa mengatasi pencemaran udara lintas batas ini. So we are so lucky to have you here, Professor Yves, to share with us, to share your knowledge, to share your experience. Nanti mungkin kita sangat berharap Profesor Yves bisa menceritakan sebenarnya bagaimana sih good neighbor provision tersebut, apa saja tantangan dalam implementasinya, apakah ada contoh kasusnya di Amerika Serikat terkait dengan hal ini, karena saya catat sebenarnya ada satu contoh kasus menarik, kasusnya adalah Maryland versus EPA, Environmental Protection Agency, di mana saat itu negara bagian Maryland dan Delaware itu tidak mampu mencapai standar udara ambiennya untuk ozon, karena pencemaran udara dari upwind state, gitu ya, seperti Pennsylvania, Indiana, itu kemudian tidak bisa membuat mereka untuk comply, dan kemudian mereka meminta adanya pemasangan alat pengendalian pencemaran udara yang lebih ketat pada beberapa fasilitas yang ada di dalam yang terdapat pada upwind state, tapi itu kemudian ditolak oleh EPA. Nanti mungkin Profesor Yves bisa bercerita juga terkait dengan hal ini, karena Profesor Yves salah satu yang mengajukan amicus curiae untuk kasus ini. Nanti mungkin kita bisa berdiskusi banyak. Akhir kata mungkin dari saya begitu saja, Bella. Selamat berdiskusi. Harapannya semoga diskusi ini dan lesson learned dari diskusi ini tidak hanya bisa menjadi diskursus hangat untuk memperkaya pengetahuan kita, namun juga untuk memperkuat advokasi kita ke depan dan bisa memberikan rekomendasi
batas dan studi kasus terkait dengan pencemaran udara lintas batas di Amerika Serikat. Berikut CV dari Profesor Richard Yves. Saya akan coba untuk bacakan. Jadi, Profesor Richard Yves merupakan Professor of Law dan Dean Emeritus dari New York University School of Law. Lalu beliau juga sudah menerbitkan 10 buku dan lebih dari 80 artikel ilmiah mengenai hukum lingkungan, di antaranya Struggling for Air, Retaking Rationality, dan Reviving Rationality. Beliau juga merupakan pendiri Institute for Policy Integrity, lembaga think tank yang mendorong perbaikan kebijakan iklim dan lingkungan hidup melalui kajian hukum, ekonomi, dan kebijakan. Profesor Yves juga sangat luar biasa, telah memberikan pendapatnya di depan Kongres dan juga telah memberikan begitu banyak amicus brief baik kepada Supreme Court ataupun appeal dan juga District Court di US. Oke, selanjutnya saya akan membacakan rules untuk diskusi hari ini. Jadi dalam pelaksanaan webinar ini, peserta diharapkan mengganti nama dengan format Gita-ISEL misalnya. Jadi nama asal instansi. Lalu yang kedua, saya juga mengingatkan bahwa terdapat fasilitas dwibahasa yang dapat dipilih oleh peserta, bisa ada di bagian bawah tombolnya. Lalu nanti peserta diharapkan juga dapat mengisi absensi di peranala sebagai berikut. Dan saya sangat mengharapkan pertanyaan yang sangat luar biasa dari audiens yang juga sangat luar biasa. Jadi nanti sesi tanya jawab akan dilangsungkan setelah pemaparan dari Profesor Richard Yves. Lalu peserta dapat menuliskan pertanyaan di fitur Q&A sepanjang kuliah berlangsung dengan menyebutkan nama dan asal instansi peserta. Pertanyaan yang akan masuk ke kolom Q&A akan dipilih moderator untuk dijawab oleh narasumber. Mohon maaf karena keterbatasan waktu, karena di New York pun juga sudah larut malam, jadi nanti akan coba untuk dipilih pertanyaan-pertanyaan yang sekiranya kontekstual dengan diskusi pada hari ini. Oke, tanpa berpanjang-panjang lagi, kita akan memulai diskusi pada hari ini. Thank you, Professor, for joining us, especially since it is already late at your place. It's just such an honor for us to have you in this panel. Hello, could you hear me?
Yes. How are you? I'm delighted to be here.
Yeah, I'm also delighted to have you in here.
Yeah, thank you for the introduction.
Yeah, thank you. So I think we could start by talking about transboundary air pollution as a concept. People seem to believe that bad air pollution in their area is caused by pollution sources inside their area or jurisdictions. In reality, many Jakartans still think that pollution from transportation, has become the sole reason for bad air quality in Jakarta. During the pandemic on March 2020, when there weren't many transportation activities in Jakarta, the air quality was still poor enough. Air modeling showed that there was still a high concentration of PM 2.5 in Jakarta during that period. We started to learn that, like in Jakarta, the emission sources located miles away from Jakarta are contributing to the worsening air quality in Jakarta. Is this similar phenomenon in the US? And why does this phenomenon happen, in your opinion?
Yes, well, thank you. And again, thank you for hosting it, and thank you for the very kind introduction. You know, as you were talking, Bella, I thought that if you, instead of saying Jakarta, said Eastern United States, you could have made exactly the same points. We have exactly the same problem. And, you know, I live in New York, which is on the East Coast of the United States. And in the States, in New York and our neighboring states, which are basically like the northeastern states, the bulk here comes from sources that are hundreds of kilometers away. Some of the big coal-fired power plants in the country are in the Midwest, in Illinois and Indiana, and that pollution travels hundreds of kilometers and ends up having a very significant impact in the Northeast. Some of the states in the Northeast are not meeting the federal standards set by our federal administrative agency, the Environmental Protection Agency. And essentially, there is no way they could meet these standards unless the pollution that comes from other states is reduced. And that's why the good neighbor provision is so important, because it's the mechanism that can be invoked to reduce pollution that comes from other jurisdictions.
Got it. But is there any culprit of this phenomenon aside from the coal-fired power plant, maybe the other industrial area?
Other industrial sources also, although electric plants are by far the biggest contributors, but other sources as well. But the problem is really a regulatory problem. You know, basically these plants need to be told how much they can emit without violating the federal standards. And one of the sad aspects of the Clean Air Act, it was our modern Clean Air Act was enacted in 1970. So it's 50 years old, it's a little over 50 years old now. And Congress was aware that a lot of pollution crossed state lines and came up with a very extensive regulatory regime to address pollution, but actually did very little to address the interjurisdictional aspect, to the fact that pollution was crossing state lines. And in fact, and this is something I explore in my book with Jack Linke, Struggling for Air, the initial Clean Air Act actually created incentives for more pollution to cross state boundaries. And the reason was that, you know, states that, you know, used to have bad air pollution now had to bring their pollution levels down in order to meet the federal standards. And one way that a state can bring the pollution levels within the state down is by sending more pollution to other states. And the easiest way to do that is by building taller stacks. I mean, the stack is like the chimney from which the pollution comes out. And the taller the stack, the less impact there is nearby, and the more impact there is far away. So the Clean Air Act was basically telling states, you have to comply with these standards. And one of the things states realized, well, one way to comply with the standards is to send more of our pollution elsewhere. And in one of my early articles about this, I actually did an empirical study of how the number of tall stacks in the United States changed after the passage of the Clean Air Act. And it increased enormously. And the reason it increased enormously was because states were basically availing themselves of this ability to send pollution further away. And there were other things. For example, states could provide incentives for polluting sources to locate close to the downwind borders, so more of the impact be felt in the other states. So if a state created an incentive for a source to locate in the downwind border, the state would still get the benefits of jobs and tax revenues, but the competition would now be felt in other states. And the Clean Air Act initially created an incentive for that. And the other thing to stress is that, and this is true in the United States, it's true in Europe. I don't know enough about the meteorological patterns in Indonesia, but I assume it's true in Indonesia as well, that there are prevailing winds. So winds don't blow randomly. In the United States, they blow from Midwest to the east. In Europe, they blow from west to east. So certain states are basically causing the pollution, and other states are being hurt by it. So pollution from the state of Illinois, which is the state in which Chicago is, has a very negative impact on New York. But pollution from New York does not have a negative impact on Illinois because the wind, on average, blows in one direction. So the Clean Air Act actually, in its effort to reduce pollution, actually exacerbated the problem of pollution crossing state lines. And for the last 50 years, we've been trying to deal with this issue. And it's really only in the last 6 or 7 years that we've acquired good tools to do that. And so it's been a very long process that is only now bearing significant fruit. And this came from a decision of the US Supreme Court in 2014 called EME Homer City Generating, EPA versus EME Homer City Generation. And that case put the good neighbor provisions of the Clean Air Act on a solid legal footing. And then since 2014, we've been trying to implement that decision. And that's been a kind of a slow process as well, and which was slowed down considerably by the Trump administration's hostility to environmental regulation. Bella, you're muted.
Yeah, I'm on mute, sorry. Jakarta is also surrounded by a lot of coal-fired power plant by 100-kilometer radius. So I would like to dive a little deep on what you have said about coal-fired power plant. As you said that coal-fired power plant is very instrumental in regard of the transboundary air pollution. Do you think the US EPA already regulated the emission standard pretty well for the coal-fired power plant? As what I've read in your book, there is also a phenomenon, I call it a phenomenon, about the grandfathering. Could you explain more about it?
Yes, that is a big problem. And that's actually causing, I think, a significant portion of the interstate pollution. So, in my book, Struggling for Air, I call it, or Jack Linke and I, my co-author and I call it, one of the real tragedies of the Clean Air Act, which I think was well-meaning, but had a very pernicious effect. So the Clean Air Act in 1970 set up a scheme to, that led to the promulgation of very stringent standards for new sources. But these stringent standards for new sources didn't apply to existing sources. And so, and I think Congress at the time thought, well, there's no point in expending effort and energy in existing sources because they're going to close down eventually, probably pretty soon. And then, they'll be replaced by new sources, which will be regulated stringently because that's what the Clean Air Act provides. But I'm a big believer that when you analyze regulatory provisions, you have to pay very close attention to the incentive they generate. And the incentives that this scheme generated were very bad ones, because it was now going to be very expensive to build a new source. For a big coal plant back in the 70s, to install a scrubber that would enable it to meet the stringent new source standards will cost around $100 million, and it's be several hundred million now. And instead, you could continue operating an existing plant with essentially no cost, no additional cost. So back in 1970, there were a lot of existing plants in the United States that were virtually obsolete. And by obsolete, I mean that they were inefficient. And so they would have probably been replaced by new plants that could produce the product more efficiently and at a lower cost. But the Clean Air Act created a disincentive for that, because now, the cost of a new plant was $100 million more. And, to save those $100 million, you could withstand a lot of inefficiency. So Congress believed at the time that coal plants had a useful life of 30 years. And many of the existing ones in 1970 were 20 years old or so. And so I thought, well, in 10 years, they'll be gone. But what's happened instead is that some of them 50 years later are still around. So, they were 20 back in 1970. Now they're 70 years old. They're more than twice their life expectancy. They're into their third life expectancy. But they're still around because they have this enormous cost advantage over new plants. And the most effective way at this point to get them to actually reduce their emissions or to close down is through the good neighbor provisions. But the good neighbor provisions were in legal limbo until the Supreme Court decision in 2014. It wasn't clear what authority the agency had to restrict interstate pollution. The agency had come up with various rules over the years, and some had been struck down by the courts. And it was really only when the Supreme Court decided this important case, EPA versus Homer City Generation, that suddenly the whole system was on a strong legal footing. And now we're still trying to implement that. But yes, you're totally right, Bella. The grandfathering of the existing plants that was part of the original congressional scheme in 1970 is a large culprit and accounts for a big part of this problem.
Got it, Professor. Thank you, Ricky. What about the air quality parameter? What is the most problematic parameter in terms of the transboundary air pollutions in the US? Could you explain more about it?
By perimeter, you mean a state granting permits, or
parameter like NOx or maybe ozone, something like that?
Well, the most serious pollutant in terms of adverse consequences is PM 2.5, which accounts for tens of thousands of premature deaths in the United States every year, and globally accounts for hundreds of thousands of deaths. We have in the United States 6 national ambient air quality standards, which are basically the standards that are set under the core provisions of the Clean Air Act, and they're particulate matter, ozone, NOx, lead, carbon monoxide. And the non-attainment provisions are mostly focused on ozone, NOx, and particulate matter. And that's where kind of the focus of these provisions lies. And to give you an example of how dysfunctional the good neighbor provisions were at their inception, is there's a famous case that dates back to the 80s where there was one plant in the state of Indiana, and it was contributing a huge proportion of the pollution in the state of Kentucky, which was right, just right downwind of it. It was not that far. It was maybe 50 kilometers away. And Kentucky had spent $138 million requiring its electric utility to meet stringent standards. It wasn't required to do this by the federal statute. It just chose to do it under state law as a way to protect the health of its citizens. But Indiana was basically now accounting for most of the pollution in Kentucky. And the only way Kentucky could stop it was by bringing an action before EPA for EPA to find that this pollution was excessive and violated the good neighbor provision. And the judge said that it didn't. It was a very kind of convoluted opinion. And it basically slowed down this whole, the development of this body of case law. And it was really only in the 1990s under the Clinton administration that there were serious efforts undertaken to give the good neighbor provision, which is a statutory provision, real meaning. And then, as I said, it was only in 2014, it took about 15 years for the regulatory regime that EPA had chosen to be upheld by the courts and to, put the whole program on a very strong legal footing.
Got it. Thank you, Ricky. Next questions is more likely about the U.S. Clean Air Act. You already explained a little bit about the history of good neighbor provisions in U.S. Clean Air Act, but could you explain a little bit more about the history and the rationale behind the adoptions of the good neighbor provisions in the U.S. Clean Air Act?
Sure. So basically in 1970, when Congress enacted the modern Clean Air Act, it was aware of the interstate pollution, but somehow thought that if you just, put regulatory standards in place, this problem would go away because there would be less pollution. So there'd be less pollution crossing state lines, and we wouldn't have to worry about all this too much. Congress also was under a different misconception, which was that it required under the statute that every state and every region in every state come into compliance with the National Air Quality Standards by the mid-1970s. And so maybe there wasn't that much reason to worry about the good neighbor provision because Congress believed that within about 5 years, the whole country would be in compliance with the National Air Quality Standards. Well, that didn't happen. It didn't happen in the mid 1970s, and then in 1977, Congress realized that not only had it not happened, but it wasn't going to happen anytime soon. So it amended the Clean Air Act and set new deadlines, which were like pushed the whole thing into the mid 80s. And then the mid 80s came around, and we still hadn't met all of the National Air Quality Standards. So in 1990, Congress amended the Clean Air Act. And then it pushed the attainment deadlines way into the future, 20, 25 years, which have now passed also. And I think it's fair to say that there is no particularly good reason to believe that we will meet all of the requirements of the national, that every region in the country will meet these requirements anytime soon. And that's in part also because every 5 years, the National Air Quality Standards have to be reviewed, and they have often been strengthened. And so even if a state was meeting the National Air Quality Standards at one particular time, once they get strengthened, then it's not meeting them anymore, and then it becomes a non-attainment area again. So in any event, in 1977, when Congress amended the Clean Air Act, I think by then it realized two things. One was that it was much more difficult to meet the National Air Quality Standards than it had assumed in 1970. And so this problem is going to persist at least for a while. And the other problem that it realized was that the Clean Air Act had not actually done much to reduce interstate pollution. And as I indicated, I think Congress didn't know that in 1977, but it became clear later that in fact it created bad incentives for more pollution to cross state lines, because that was one of the ways that a state could bring itself into compliance, was basically by sending more pollution elsewhere. So Congress adopted this provision, which basically says that sources in one state cannot contribute significant non-attainment in other states. It says other things as well, but that's the main one. But then the question has been, well, what does contribute significantly actually mean? How much is significant? And first the agency struggled with this issue, and eventually the agency came up with a way of thinking about it, and then the court struggled with this issue. And so this all took a long time. But before we get there, I wanted to, and this is actually connected to one of the questions in the chat, the first of the English questions, because I can't understand the other ones. So, which is a very good question. So there are basically three different ways in which a downwind state can avail itself of the benefits of the good neighbor provision. So, and let me go through them. And one of them has become dominant in recent years, but all three have played some role. So one way is whenever a state revises its state implementation plan, a state implementation plan is a plan that a state comes up with mostly to show how it will comply with the national ambient air quality standards. And anytime a state revises its implementation plan, a downwind state can complain to EPA by filing comments and say that this revision of the state implementation plan violates the good neighbor provision because it allows for too much pollution to reach the downwind states. Now, this provision isn't really invoked very much because in these comments, you can only complain about the sources that are subject to the revision of the state implementation plan. And so it might not be those sources that are causing the problem. The problem might be caused by all the other sources, the ones that are not subject to the revision. So it's a pretty limited remedy. It would have been a more important remedy if it had been around from the beginning when the states first got their state implementation plans approved, because then the whole state implementation plan would have been reachable. But the provision didn't exist in 1970, so it didn't do any good then. So this is one of the ways a downwind state can complain about excessive upwind pollution. It is not particularly important anymore. A second way is it can file a petition with the Environmental Protection Agency complaining that particular sources in upwind state are causing excessive pollution. And this provision actually has been used, and it was used actually recently during the Trump administration because it's often used when the agency is actually hostile to the claim. This is a way of forcing the agency to take it seriously because you file a petition, it's like a complaint that then requires the agency to adjudicate it. The Trump administration found all kinds of reasons that we can talk about if you're interested for always finding that there had been no violation. And it did so mostly by putting so much of the burden of making the case on the downwind state that it was hard for the downwind state to make it. So this provision has had some influence, but it's mostly been used during Republican administrations that, at least in the modern era, are traditionally hostile to environmental regulation. The most important way of dealing with this has been through what came to be known as SIP calls. SIP is the acronym for a state implementation plan. And this is EPA, the federal agency, determining that a state implementation plan is inadequate. Now, this is kind of a weird thing for them to do because these are all state implementation plans that at some earlier time they had approved. So it's basically admitting that they made a mistake. They approved the state implementation plan, finding that they complied with all the provisions of the Clean Air Act, But now, years later, they decide that the plan was inadequate. And, from the perspective of our discussion, they decide it's inadequate because it allows excessive pollution to reach a downwind state. And so, for example, the cross-state air pollution rule that was mentioned earlier in the program is a rule that EPA adopted, finding that state implementation plans of like 26 states were inadequate, and that they needed to more stringently control their sources to avoid contributing significantly to non-attainment in downwind states. And there have been a number of rules like that, that all of which have been adopted in Democratic administrations. In the Clinton, that's actually not true. One of them was actually adopted in the Bush administration. None of them were adopted in the Trump administration. But they're mostly rules from the Clinton and Obama administrations. And EPA versus EME Homer City Generator was a Supreme Court's decision upholding the cross-state air pollution rule. And that was what I kind of said was this kind of important moment that put the good neighbor provisions on a strong legal footing.
Thank you, Ricky. So could you expand a little bit more how to determine which sources is deemed significant and which one is deemed insignificant? Do we use science to determine this factor?
Yeah, we definitely use science, but it's not like, if you contribute like 2% or 10% or whatever, that makes you significant. That's not the way we've done it. It, conceivably could be done that way. But under the cross-state air pollution rule, EPA adopted a two-step process, which has been followed since. So the first step is EPA determines that certain sources are de minimis. And so any source that contributes less than 1% of the pollution in a downwind state is deemed de minimis and is then not subject to any, regulation under the good neighbor provision. So it's the other sources that are then subject to further inquiry. And EPA has taken the position that the way you determine significance is by the cost of reducing the emissions. So EPA, for example, will say, we did some modeling, and this is kind of part of the science, and we figured out that if sources spend, I don't know, I'm picking a random number, let's say $500 per ton of pollution reduction, that will lead, if all the sources in the affected states, the upwind states, the downwind states, and all of them in the whole region, spend $500 per ton of pollution reduction, then the ambient standards will be met everywhere. So EPA does that through computer modeling, and then it says, okay, since that's what it takes to meet the ambient standards, we're going to require any source for which it is cheaper to reduce air pollution to do that. So the idea is that EPA is searching for the cost minimizing way of meeting the ambient standards everywhere. So it could, for example, impose additional restrictions in downwind states, because sources in the downwind state are also contributing to the problem in the downwind state. Sources in Jakarta are contributing to the problem in Jakarta. It's the fact is that some sources that are not in Jakarta are also contributing to that problem. So it's saying, well, if sources in Illinois can reduce their pollution more cheaply, we're going to impose those reductions on sources in Illinois. But if it's sources in New York that can do it more cheaply, we'll impose those reductions on sources in New York. And that's what was at issue in the challenge to the cross-state air pollution rule, which was whether EPA had the authority under the Clean Air Act to use essentially a cost metric to determine what emissions were significant and how to allocate the reductions. And the Supreme Court said that was okay.
Thank you, Ricky. So I think we will try to answer one question from Q&A. You could hear it from the interpretations from English to Indonesia because I will read it in Indonesian.
Okay,
Ya. Satu pertanyaan dari Pak Fernando Sinaga. Jadi ada pertanyaan bagaimana isu pencemaran udara ada di Amerika dan bagaimana dampaknya terhadap kesehatan dan ekonomi. Bahwa persyaratan yang lebih ketat biasanya dapat memiliki konsekuensi ekonomi bagi produsen, mobil, dan perusahaan yang mengeluarkan polutan. Seperti apa kebijakan politik di Amerika untuk menyeimbangkan kedua hal tersebut? Jadi bagaimana menyeimbangkan antara perlindungan lingkungan hidup itu sendiri dengan ekonomi ataupun pembangunan. Terima kasih. Silakan dapat dijawab, Prof.
So that's a great question. And it varies by environmental regulation. So for the national ambient air quality standards have to be set without regard to cost. But essentially, for all the other environmental regulations, cost can be taken into account. So the national ambient air quality standards have to protect the public health with an adequate margin of safety. Now, this has been a difficult inquiry because in the early days, like in 1970, Congress assumed that there were thresholds below which there was no adverse impact from pollution. And so the idea was, well, maybe the national ambient air quality standards would be set under the threshold, and they would then provide protection, to everyone. But we soon learned through scientific advances that these contaminants are generally non-threshold contaminants. So they have negative impacts at every concentration. And the question is, at what point do you stop making the standard more stringent? We probably are not going to go down to zero because zero would make it impossible to have an industrial society. And how close to zero do you get? If we could look at costs, we could maybe balance the costs and the benefits, but for the setting of national air quality standards, we cannot look at costs, at least not explicitly, although there's kind of some views that maybe the agency cheats from time to time and takes them into account anyway, but they're not supposed to do that. And so basically the agency is deciding, should you be subject to a 1 in a million probability of dying from exposure 1 year to some contaminant, or should it be 1 in 100,000, or should it be 1 in 10,000? And, those are hard judgments to make, obviously. Now, for all other environmental regulations, like, for example, regulations on individual sources, as opposed to the national air quality standards regulate the pollution concentrations in the ambient air, but they don't impose any particular regulation on any source. It's just that for this thing to work out, the sources have to be regulated in a way that allows the jurisdiction to meet the ambient standards. For emission standards on a particular source, costs are taken into account. And every president since 1981, aside from that, has had in place an executive order that requires that significant federal regulations be justified by cost-benefit analysis. And so basically, the agency has to look at the costs of having a more stringent rule, which typically are compliance costs for industry. They have to go out and buy equipment and so on. Some will close down. There might be some dislocations of workers and so on, against the benefits to the health and the environment, to be beneficial to public health, longer expected lives, fewer hospitalizations, fewer cases of asthma, heart attacks, strokes. Those are all common consequences of air pollution. And also to, environmental goods, environmental attributes, water, species, and so on. So most of the time, for most regulations, we're balancing these things. And most environmental regulations have very high net benefits. Kind of opponents of regulation often cite, the costs, we'll lose jobs, we'll do this and that. But the truth of the matter is that when you actually look at a well-conducted cost-benefit analysis, almost all the important regulations have benefits that far exceed the costs.
Thank you, Ricky. Jadi Bapak Ibu rekan-rekan sekalian, sejauh ini Profesor Ricky sudah menjelaskan cukup komprehensif terkait dengan bagaimana peran EPA dalam meregulasi pencemaran udara lintas batas dan juga bagaimana sejarah ataupun kebijakan dari pencemaran udara lintas batas itu sendiri. Saya ingatkan sekali lagi kepada Bapak Ibu rekan-rekan sekalian untuk menggunakan fitur Q&A untuk bertanya. Lalu juga jangan lupa mengisi absensi agar semuanya terdeteksi dalam acara ini. Okay, Ricky, so next questions for you. I want to drill a little bit explanations about the administrations. From what I read and from what you said, the Trump administration tried to curtail a lot of environmental regulations during the administration. And also, I read your book, the Reagan administration is also, I could say that a little bit curtailing also the provisions during the administrations. So how the Clean Air Act doing during both the Trump administrations and maybe during the Reagan administrations, and what could we do maybe during the administrations that is not really protecting the environment, since the Indonesia is now currently, we have a government that also tried to curtail many of our environmental regulations.
Yeah, so, it's an interesting phenomenon in the United States because the modern environmental laws, as I kind of, indicated, date back to 1970. And the president at the time was Richard Nixon, who had many problems, but he actually was quite good on environmental issues. And the Republican Party at the time was quite good. And the support for the 1970 Clean Air Act was bipartisan. Democrats and Republicans supported it. And there was essentially bipartisan support for the major environmental laws through around 1990. And then it collapsed. I mean, since then, Republicans have become extremely hostile to environmental protection. Democrats have been, more sympathetic. And we've never actually seen an administration as hostile to environmental protection as the Trump administration. I mean, the George Bush administration wasn't great, but it was not nearly as pernicious as the Trump administration. So we've just come out of a very bad time. And obviously we have a much more protective administration now, and the Biden administration has made climate change, environmental protection, environmental justice a centerpiece of its policies. And, it's only been around for a little less than 6 months, but it's actually done a fair amount to move things forward. So what happens when administrations are hostile? Well, a whole bunch of things happen. We have a federal system in the United States, and this discussion has been mostly about federal law. State has environmental. Some states have, quite stringent environmental protections, and during hostile Republican administrations, the states end up doing more on the state side. Now, the problem with states taking the lead is that, the United States is now a deeply divided country. And so states with democratic governments, actually do a fair amount and can often, step in and do things that the federal government isn't doing. So New York and California. But states with Republican governments, tend not to. They tend to follow the leads of the Republican administrations in Washington. So you see actions by some states and not by others. The other thing that can be done is litigation. So every time the Trump administration tried to deregulate, try to, repeal an Obama administration regulation or weaken it, they were sued. And typically they were sued by two coalitions. One was a coalition of the major environmental NGOs, the big national environmental NGOs. And that's kind of where we, Policy Integrity, the group that I run, would typically file amicus briefs in support of these major NGOs, which were the parties bringing the case. So we wouldn't bring the case, we would basically support them, and mostly we would support them on the economic analysis. And so the major NGOs were one stakeholder, and the other big stakeholder was the democratic states, state attorneys general for democratic states. So often the Trump administration would be sued by, 25 states, 27 states. We have 50 states in the union, so there's like more than half the states were now suing the federal government. And those suits, for the most part, are extremely successful. The Trump administration did a very sloppy job justifying its deregulatory actions. And under our Administrative Procedure Act, regulations have to be justified. You can't just sort of like say, okay, we're repealing this. You have to explain why you're repealing it and what the problem was and why you think this will lead to a better outcome and all that. And all of these reasons are then subject to challenge. And because the Trump administration really had this respect for these rules, it didn't do a very good job explaining, this is a regulation, so it must be bad. And they just kind of like just did it. And the regulations were challenged. The Trump administration won only about 20% of the cases, which was really an atrocious record, because typically a presidential administration to
Recording
a 20%
in progress.
win rate. So in the end, a lot of their efforts to dismantle Obama administration regulations failed. And that made the Biden administration to now undertake a more serious effort to regulate. So basically, the administration in Washington is hostile. A lot of things happen at the state regulatory level, and then there's a lot of litigation against the actions of the federal government, done both by NGOs and by the attorney generals of democratic states.
Thank you, Ricky. I will try to combine again the discussion with questions from the audience. So there is one question in Indonesian, so you could hear from the interpretations. Satu pertanyaan dari Stella Winata. Jadi idealnya seberapa sering sains dan standar dievaluasi dan diperbaharui dalam konteks hukum untuk mewujudkan udara yang sehat. Misalnya kalau misalnya kita bicara soal konteks BMUA, kalau di Amerika Serikat kan memang diperbaharui setiap 5 tahun sekali, tapi tidak ada kewajiban seperti itu di Indonesia. Menurut Ricky, bagaimana baiknya?
Yeah, so it's basically, the standards that have to be revised are the National Air Quality Standards, which are probably the most important standards, because they set as I indicated, the maximum permissible concentration of pollution in the ambient air. And under the statute, they need to be revised every 5 years, which is kind of a guarantee that they will take into account the most recent scientific evidence. So the agency needs to look and see, are there new studies that show that this is actually more dangerous than we thought, that more people are dying, more people are getting hospitalized, and so on. And if so, the agency has to, do something about it, as like make the standard more stringent. Now, there are also ways of getting at sources through, for example, the good neighbor provision is not kind of changing any standards. It's just finding that, sources are, essentially violating a statute requirement that was always there. And it's just that we hadn't focused on this until now. And so now we go in and say, yeah, they actually are violating this requirement. I think it's good. Now, it's also the case that even for provisions where the statute does not require a periodic revision, we have a process in the United States which works sometimes. It usually doesn't work, but it does work sometimes, which is you can file a petition. So you can petition the agency and say, look, I mean, there's all this new scientific evidence showing the stuff is a lot worse than it was when you put your regulation in place. You have an obligation to, look into this petition and consider to strengthen the standard. So, every once in a while, some group files a petition of that sort, and every once in a while, seldom but not never, those petitions are successful. But I think it is important. I mean, science is evolving, and it is important through some way or other to have environmental standards reflect improvements in science. Now, you don't want to do it every day because that would be, very burdensome for the agency, and there aren't new studies every day. So you have to find some, I would say, 5 to 10 years is probably the right range. Sometime in a 5 to 10 year range, you should, through some mechanism, try to force an agency to take new scientific evidence into account and consider revisions of environmental standards.
Thank you, Ricky. So I will try to back to our discussions about the good neighbor provisions. Is there any recent good neighbor provisions cases that are interesting to be learned? And also, can you explain this certain case? And I would like also to ask you about how effective these petitions, since it took a lot of time for the state to petition it from example from the, and then if the EPA cancel their petitions, they will try the court, if I'm not mistaken, and it takes a lot of time. So what if do you think petition?
Let's read only one case. You should read the Supreme Court case. EPA versus EME Homer City generator. That is really the very important case. And there've been a number of subsequent cases, but they deal with more technical and less issues that are less across the board significance. So I would, focus on that. If you just Google Environmental Protection Agency versus EME Homer City generation, you'll find the opinion. I'll put it in the chat. I'll put the name of the case in the chat in case, just to make it easier. Can the attendees see the chat? Oh, I can. I can send it. Okay, got it.
I think you could send it to me. Yeah, there is it.
Yeah, if you just Google the name of the case, you will get you will get an opinion. You'll be able to read it. I will read that one. The subsequent cases have been more technical and less significant, so I would not worry about them too much. I think that's the one that will give you the best sense of where things stand on the legal provisions. Now, in terms of how effective it is, it's actually been very effective because it turns out that the Good Neighbor provision has been one of the few ways that under the Clean Air Act, we've been able to reach emissions by existing sources. Because, I was telling you, there was kind of this really bad incentive effect caused by regulating new sources, not existing sources, which is to keep existing sources in operation longer, potentially forever, because they had such a big cost advantage. But this is one way of removing that. And so it is significant. But as I indicated, it took a very long time. I mean, if you think of the dates, it was like 1970 was the initial statute. It wasn't in the Good Neighbor provision then. The Good Neighbor provision was added in 1977. It took until the 1990s for the first serious EPA regulation implementing Good Neighbor provision to happen, and it took until 24. And then, there were a number of regulations, and some actually were upheld by the lower courts, but others were struck down, and so the whole program was in legal limbo, and it really was in 2014 that was put on a solid footing. But now that it is on a solid footing, it's easier to invoke it. And the Biden administration is clearly going to, in my mind, is clearly going to use the good neighbor provision multiple times, I would imagine, to constrain upwind pollution. Now, one problem in the United States now is that, you know, we've become a very litigious society with respect to environmental regulation. Environmental regulation is controversial, and it's part of the political, you know, big political gap between the parties. You know, it's basically one party is much more sympathetic and the other is much more hostile. And so any big regulation that EPA promulgates ends up getting litigated. And that means that it takes years to resolve it. I mean, for EPA to actually promulgate a rule like this probably takes a minimum of 2 years, because rules of this sort have to be done through what we call notice and comment rulemaking, which means that EPA proposes a rule and explains the basis for the rule and explains why it's proposing it and all of that. And then there's a comment period where anyone in the country, any group or individual can comment. And then EPA promulgates a final rule. And at that point, it has an obligation to respond to all the comments. And if it doesn't respond well to the comments, that can be an argument for judicial review of the rule. So this is going to be, and then, you know, once the rule is promulgated, you have a final rule, it is inevitably challenged. And best case scenario, it takes a year, but it could take a year and a half for the judicial proceeding. And that's assuming the case doesn't go to the Supreme Court, which could add another year. So, you know, start to finish, one of these significant rules could take 4 or 5 years to do. And that is, you know, a problem. I mean, it obviously means that we can't react very quickly to problems as they arise, because it's going to take like 4 or 5 years to get something like this actually to happen.
Thank you, Ricky. So we have 13 minutes left on our discussion. So I think I will jump directly to the Q&A part. So we got questions from Ahdan Wafi from University of Indonesia. He asked, in my view, both Indonesia nationals and state level government didn't pass much of economic type instrument to address air pollution issue. We depend on CAC instruments or command and control a little too much, but the shift towards economic instrument might come soon. The most prominent candidate for this economic instrument so far might be in a form of environmental taxes or environmentally related taxes. The difference between the two is their aim and revenues allocations, and so on. And what can we learn from the US practice to avoid this kind of threats, especially from a taxation instruments and for nationals or even state level? Please, Ricky.
Yeah, so we don't have experience in the US with environmental taxes. You know, essentially, when we've economic incentive schemes to replace command and control regulation, they've tended to be marketable permit schemes. So, for example, the US established a nationwide market for acid rain, the 1990 amendments to the Clean Air Act. And so basically Congress defined the total number of tons of sulfur dioxide that could be emitted, and then kind of basically the allocation of this was done through trading. There has been a lot of discussion for many years now whether we should have a carbon tax to combat climate change. There's actually been less discussion with respect to the kind of local pollutants like PM 2.5 that we've been talking about here. But certainly carbon taxes are a thing that you know, one talks about. And I think the question is raising a very important, which is, you have to decide what you want your tax for. You know, I think the reason to do the tax area is to create incentives for like the optimal, you know, generation of pollution. You know, so the idea is that these economic incentive schemes can give us any level of pollution reduction we want at less cost than command and control regulation. Command and control regulation is more costly because the regulator doesn't really know whether it's imposing, a requirement on a source that can reduce pollution very cheaply and could actually reduce twice as much pollution at a quite reasonable cost, or whether it's imposing it on a source that for which it's so expensive to reduce this pollution that actually it's not socially desirable for that source to reduce its pollution. It's better for some other source to reduce its pollution. And economic incentive schemes take care of that. Taxes do it, and marketable permit schemes do it. So far in the US, we've had more experience with marketable permit schemes than with taxes, although there has been significant interest in the possibility of having carbon taxes. But right now, it's probably not going to happen because the Environmental Protection Agency does not have the authority to impose carbon taxes through its regulatory powers. It can impose regulation. It can maybe even allow some trading to take place under the regulation. So for example, under the good neighbor provision, when I said it imposes these requirements on sources that can reduce pollution more cheaply, it then technically established a trading scheme where, it used that to figure out how much reduction had to be. And there was some possibility of trading. So, someone who could reduce its pollution more cheaply could reduce its pollution more and sell those permits to someone for whom it was more expensive to do that. And that ends up reducing the overall cost. So there is actually interest in economic incentive schemes, but for the most part, our experience has been on the marketable permit scheme, not on the tax side. Taxes would have to be imposed by Congress. And Congress is very deeply divided around environmental issues now. And there's another feature of the US very difficult environmental legislation to be enacted, which is that while our House, which is the lower chamber of our legislature, operates majority rule, our Senate operates on a supermajority rule. That is, in order to advance legislation, you need to get 60 out of 100 votes. Once you get 60 votes to move the legislation forward to a vote, you only need 50, you only need a majority to actually approve the legislation. So it's not a supermajority requirement to approve the legislation.
Recording in
Practical matter, you need to get 60 votes in the Senate. Right now, the Senate is split 50-50. When it's split 50-50, if there's ever a 50-50 vote, the vice president can break it, and the vice president is a Democrat. So you could get, if the Senate were operating on a majority rule, we could actually get environmental legislation. But it's not operating on a simple majority rule. And so you basically need to get 10 Republicans. And under the current division of the parties, there's no scenario that I think is realistic under which 10 Republicans would vote for any serious environmental legislation anytime soon. That could always change because the parties views shift over time. But if you plan for the next 2 years, 4 years, 6 years, just seems extremely unlikely. So we're probably not going to have major environmental taxes because for this next period, we are stuck to whatever the agency can do under its regulatory powers. And that does not include the possibility of imposing taxes, although it does allow it to have quite stringent regulations, maybe to allow for some kind of trading schemes, but not to impose taxes.
Thank you, Ricky, for your answer. So we are now in the end of our sessions. Do you have any closing statement?
I don't have a closing statement. I really enjoyed this, and I'm so excited that you're all interested in these issues. I think that one thing that you probably should worry about if you are trying to basically build a legal regime that is designed to control pollution from other jurisdictions is what the legal basis is for doing that. I mean, in the US, the legal basis is this statutory provision that says that it's a violation of the Clean Air Act for sources in one jurisdiction to contribute significantly to non-attainment in other jurisdictions. And that's the hook for all of this stuff. without that statutory provision, it's unlikely that all of this apparatus could have grown. So, I guess my advice as you try to think about this is, what is going to play the role under your law that this one statutory provision in the Clean Air Act plays under our law? Because if you can find that, or can make a legal argument suggesting that it's embedded in it, or whatever you can do, or, then I think you can actually benefit to some extent from the U.S. experience, because, we've been at this a lot and so on. But you need to find the hook, because otherwise, you can imagine a hostile court saying, yeah, that works in the U.S., because the legislature explicitly authorized something like this. Show me where the legislature in Indonesia authorized that. So I think the first thing is to come up with a legal theory of where that is. And if you can find that, then I think there's a on how to allocate the pollution control. That's, again, an easy question, because if, Jakarta is violating some standard, someone might say, well, that's because there's too much pollution in Jakarta. And because there is pollution, just like there's too much pollution in New York, there is pollution in New York. And every city has pollution because there are cars. And as you pointed out, Bella, cars aren't sometimes the biggest part of the pollution, but they're part of the pollution. So, so the question is then, how do you then decide up to what point do you regulate the pollution that comes from the upwind jurisdiction, and to what point do you regulate the pollution that comes from within the jurisdiction? And the rule can't be that you impose all and think
Recording in
carefully
progress.
about, coming up with a sophisticated way of allocating the pollution control burden between the jurisdiction you are in, jurisdictions that are sending pollution your way. Because if you just build these all on the part of the other jurisdictions, it's not going to seem serious. And so I actually think we did fairly well there. So it's probably something to be learned. And obviously, now that we've had this connection, if you are trying to come up with legal theory, I'm happy to try to help. I have colleagues like Jack Linke, who's my co-author in the book, and others who are real experts in the good neighbor provisions, and we're happy to help if we can.
I hope we could correspondence further in this issue, Ricky.
Yeah, well, you have my email and you know how to reach me.
Yeah.
Thank
you so much.
Conversation very much, and your questions, Bella, were terrific, really terrific, and the questions from the audience were also terrific. So I was very excited that you've given so much thought to this, very vexing environmental problem.
Thank you so much, Ricky, for joining us today. I know it is late at your place, so if you want to leave the room, it is fine for us. Okay. Thank you so much.
Because it is kind of late at night in New York, but thank you very much again, and keep in touch. Good night.
Thank you so much. Bye-bye. Good night. Bye-bye.
Good morning for you. Good night for me.
Terima kasih Bapak Ibu yang telah hadir dalam diskusi hari ini. Mohon maaf untuk pertanyaan yang tidak terjawab, yang sudah mengajukan pertanyaan dan tidak terjawab dalam diskusi hari ini. Saya akan mencoba untuk memberikan sedikit kesimpulan dari diskusi yang sudah terjadi pada hari ini. Jadi yang pertama adalah setiap regulasi akan menimbulkan insentif bagi para aktornya. Clean Air Act memberikan insentif bagi sumber pencemar udara, utamanya dari PLTU tua, untuk menghindari beban biaya untuk mengendalikan pencemaran udara, karena mereka dikecualikan dari standar PLTU baru. Lebih parah lagi, emisi dari PLTU tua ini dibuang ke negara bagian lain sehingga menimbulkan masalah pencemaran udara lintas batas. Lalu selanjutnya dalam menyusun kebijakan pencemaran udara, pertimbangan biaya dan keuntungan dari kebijakan ini perlu dipertimbangkan. Benefit dari kebijakan ini bisa lebih besar dari biaya yang dibutuhkan untuk mengendalikan pencemaran udara. Selain itu, penting untuk menentukan legal basis untuk membangun rezim hukum. Tanpa statutory provision ini, aparatus tidak akan berkembang. Jadi kita perlu untuk menemukan legal hook, seperti tadi dikatakan oleh Ricky, kita perlu untuk menemukan legal hook yang tepat untuk aturan pencemaran udara ini. Akhir kata, saya sebagai moderator mengucapkan terima kasih kepada Bapak, Ibu, rekan-rekan sekalian yang telah hadir dalam diskusi hari ini. Mohon maaf apabila ada kesalahan dalam kata ataupun perbuatan dalam diskusi ini. Selamat siang Bapak Ibu, semoga sehat selalu. Sampai jumpa pada diskusi berikutnya, mengingat juga ada diskusi ISEL lain dalam waktu dekat. Apakah bisa di slideshow-kan sebentar? Jadi akan ada diskusi ISEL, kuliah umum lain dalam waktu dekat, yaitu yang akan dibawakan oleh Profesor Rahmat Safaat, yaitu pada tanggal 13 Juli 2021 tentang rekonstruksi politik hukum tata kelola pertambangan mineral dan batu bara berbasis keadilan sosial dan keberlanjutan lingkungan, serta oleh Profesor Muhammad Ramdan Andri Gunawan Wibisana mengenai antroposen dan hukum lingkungan dan masa-masa penuh bahaya. Keduanya merupakan penggawa hukum, Bapak Ibu rekan-rekan sekalian, jadi kalau bisa jangan lewatkan seri kuliah umum lingkungan dan sumber daya alam dalam rangka ulang tahun ke-28 ISEL. Terima kasih Bapak Ibu sekali lagi atas kehadirannya, semoga sehat selalu.
Recording stopped.